What's up and welcome to Advanced Strategy. This is Kristen. I got a letter from a subscriber, Cecilia in Florida, and she sent me the cash for the phone consultation. I was able to receive it just fine. I'm very glad that she did. Thank you, Cecilia, for prompting me to make this video because I like to think that foreclosure is my specialty. What I'm going to give you in this video is 3 documents that I would use to stop a foreclosure. And I'm going to show you how to enforce your paperwork for research purposes only, for the purposes of doing more research. Now, it's one thing if these banks want to continue to allow you to make payments on a loan that originated in a fraudulent transaction. But it's another thing when they start coming after the property and they want to come and take the house now, isn't it? So you can rescind your signature from any contract, especially for fraud. If you find out that there's fraud, then of course you won't leave your signature there to become a party to it. Now would you? I hereby formally rescind and withdraw my signature from the document titled so-and-so, dated so-and-so, on the grounds of misrepresentation, lack of consideration, lack of informed consent, fraud, duress, or material error. This rescission is effective immediately, and I no longer consent to be bound by any terms, obligations, or representations within said document. I demand that all copies of this document bearing my signature be rendered null and void. Please confirm in writing within 10 business days that my rescission has been acknowledged and that the document is no longer enforceable against me. Failure to comply may result in further legal action. Now, reason for rescission: clearly state why you are withdrawing your signature, for example, signed under false pretenses, coercion, or mistake. Delivery: send via certified mail, return receipt requested, or email with read receipt for proof of delivery. Because, of course, how did you get into this mess in the first place? With your signature. So, however you got into it, you can get out of it the same way, by removing your signature. And furthermore, how did you really get into this mess originally? With a promissory note. Guess what? Yes, you can write the bank another promissory note to get out of the situation that you're in now behind it. Oh, yes, you can. That's something you can talk to a lawyer about or do some research on the international promissory note. You can watch a video by Michael Tellinger about the international promissory note. He does a great job there. But the good part about this notice of rescission of signature is that, legally speaking, it is valid the moment you send it off to them. Boom, that's it. It is legally valid. Your signature will then be considered rescinded off the document. And if they don't like it, they would have to now file a lawsuit about that against you and initiate legal action against you to retaliate, or to rather rebut the signature being removed. The signature is removed once you send off that notice. Get it notarized and recorded, and when you deal with the clerks at the recorder's office, just send in your paperwork to them by mail. They have to deal with it that way. They don't need to see you in order for you to have them do their job. In fact, it can get in the way sometimes. The next document is very important: the Affidavit of Fraud. Now, if they don't rebut your Affidavit of Fraud, then the UCC law says that a dishonor has occurred. There are many reasons. There's so much fraud involved in these loans, these so-called loans. I can't even get started on all the many reasons how fraud can be involved. But the Affidavit of Fraud is something very serious. Request for relief: immediate halt to foreclosure proceedings, rescission of any fraudulent documents, a full audit of my loan file, restitution for damages. have it notarized, have it recorded. File it with the court. If a foreclosure case is pending, send it to the lender via certified mail, return receipt requested, and submit it to the regulators, the Consumer Financial Protection Bureau. I had a situation with a servicer who was very powerful, and I checked with the Secretary of State in my state just to make sure they were registered to do business in our state. And guess what? They weren't, or the paperwork was out of date, whatever it was. But I reported them right away to the Consumer Financial Protection Bureau, and that servicer did drop out of the game because of that. And then don't forget, in most states, the statute of limitations is 4 years on a loan, and this is just a loan like any other loan. It is what you say it is. You're the principal. Rescind your signature from the deed of trust. Don't forget to put the book number and page number. And I would put a legal description of the property as well. And remember, now they have to rebut your affidavit of fraud point for point with their own affidavit. And that their affidavit needs to be sworn, the facts therein need to be sworn to be true under penalty of perjury under the laws of the state that they are in. And guess what? They are never going to rebut your affidavits because no one wants to stick their neck out and put their name on the line and take responsibility and guarantee that the facts are true under penalty of perjury. I will be shocked if one of these bank representatives ever did rebut an affidavit. That's one of the few weaknesses they have, that nobody wants to put their name on the line and swear that the facts are true. And you have to use that against them. If you want a judgment, bring it. This is how you do it. Now, because an affidavit of fraud, they have to deal with that. They cannot just ignore that. Now, this next document is super important. And if I were you, I would send a copy to the state bar that oversees all the lawyers. You have to revoke the power of attorney. That is the authority which they are operating under, the authority that you gave them. Okay? You need to revoke their power of attorney to the foreclosure department. Dear so-and-so, I, the principal, hereby immediately revoke and terminate the power of authority dated so-and-so, which granted so-and-so authority to act on my behalf concerning the matters related to my loan. Effective immediately. All authority granted under this power of attorney is fully revoked. The agent is no longer permitted to sign documents, negotiate loan modifications, communicate with lenders, or take any action regarding my mortgage or foreclosure. Any actions taken by these agents after this date are null and void. Cease all communications with the agent regarding my loan. Do not accept any documents, agreements, or instructions from the agent unless I provide written consent. Confirm in writing that you have received this revocation and update your records. Notice of potential fraud or misrepresentation. If the original power of attorney was obtained under fraud, undue influence, or misrepresentation, which yes it was, I reserve the right to pursue legal remedies. Have it notarized. Key steps after sending. Send via certified mail to the agent and the lender. File it with the county recorder. I would. It's very important. Follow up with the lender to ensure compliance. Don't just assume they got your paperwork so they know what time it is. Consult an attorney if the agent or lender refuses to acknowledge the revocation. And contact the state bar because, I've made plenty of complaints about plenty of lawyers and attorneys to the bar, and they don't seem to care about anything that these lawyers and attorneys do. But they did seem to care about these attorneys operating after a revocation of power of attorney had been filed. They did seem to care very much about that, as well they should. Now they lost their authority to operate and to act on your behalf. Now what are they going to do? They're going to have to come up with something. They may still fraudulently proceed, but these are all things that you'll be able to hit them back with in court then later and really stick it to them. Now, this is the letter that you should consider writing for research purposes only. Dear Bank Representative, it has come to my attention that there is some confusion regarding how the loan was funded. I need to make sure that the one who funded the loan is the one who gets paid back. Since you have initiated foreclosure proceedings against the property, then I need to see a copy of the book entries which your bank or the bank who originally funded the loan should have on file, if you are the proper party to receive payment or to enforce the foreclosure clause of the original contract. All I'm asking is for a copy of the book entries that originated the loan in question. Failure to respond on your part means that you agree that you are not the proper party who has the authority to call in the note or to initiate foreclosure proceedings. Did the promissory note fund the transaction? If so, then I will require a refund of the payments. Thank you for your timely response. Please send your response to your name, care of the Notary Public, and the notary's address from the homeowner. Now, the notary will help you out with this because it's just repeat business for her. Get a notarized certificate of service from the notary. And then the last document I'm going to show you is critical. We're finding this out, and I'm glad we're finding this out, to enforcing your paperwork. It's all about this notice of non-response. And you're going to get this from the notary. She's going to issue a certificate of non-response. Okay, so this is what goes out to the lender. Dear Bank Representative, this letter serves as formal notice that as of such and such date, our office has not received the required documentations, payment, or communication from your organization regarding the specific lien process or case number and sent on such and such date. Background: on such and such date, a lien was filed, recorded against the property, or a letter was sent asking you for the book entries, or whatever it is you want to ask them. Figure out what questions you want to ask them that they don't want to answer. And no response has been received. Let them know. Give them a chance to respond, and when they don't, hit them with the notice of non-response. Now, this notice of non-response is proof of their dishonor. Whoever goes into dishonor first loses. Unless you can get yourself back in honor and get them into dishonor, then that would be great. So this is the way that you take responsibility for your own court cases and settle them yourself, non-judicially, and then you keep all the proof of the letters you sent and the notice of non-response, a certificate of non-response, certificate of service proving that you sent these letters and proving that they did not respond. And bam, submit that to the judge, file those into the court record, and don't ask for judicial notice, ask for a judicial review of your administrative process and for summary judgment in your favor. And you're going to get it, because this is what you're supposed to do anyway. Everyone who has a court case was supposed to send letters to the people first to try and solve the matter for themselves. So you've just done something really responsible here. You settled the matter yourself, you put them in default yourself, you saved the court a lot of time, and you saved the judge the bother of having to sit there and listen through all the sordid details of your private business and your private interactions with other people that should really have remained private. And boom, you just made his job very easy. There is no controversy. They already agree through their silence and non-response. Because when they get that affidavit of fraud, they are required to respond to it. Or that means they agree with everything that was said in that document. Silence is acquiescence. Now, this is a template or another sample of the notice of dishonor through default via non-response. This letter serves as formal notice of dishonor and default under the terms of the agreement or under the terms of the letter that was sent due to your failure to respond to prior communications and resolve the confusion regarding the contract terms. Because if they can't explain the contract to you, then it's not binding on you. If they refuse to show you the book entries, proving that they originated the loan and that they actually loaned you money, then there is no debt to collect. This is how you win your legal battles before you ever go to court. This notice of non-response. And furthermore, this is how you would also enforce your paperwork if you were to send another promissory note to the bank, which of course, yes, they will accept it. They will salivate all over it and they will accept it. If they don't send it back to you in 3 days, then they accepted it. But then you have to follow through with the notice of non-response process from the notary. That's the only way. Nobody's ever going to do what they're supposed to do because it's the right thing or because you had a good argument. Even if the law compels them to do it, they're not going to do it unless you know how to enforce it. Enforce your paperwork on them. Enforce your position. And force them to act, to do their job, or whatever else that is required of them. Now, don't hesitate to ask the bank these questions. You're not crazy for asking them for research purposes only. I do not give legal advice to anyone. Please be advised. However, let me tell you something. The smart people who, when they find out, if they find out, first of all, nobody ever finds this out, by the way. I would say my guess would be maybe 99% or more of the people in this world never find out that the bank didn't actually loan them any money. Okay? So first of all, we're lucky to be finding this out at all. But let me tell you, the smart people who find out, when they do find out, here's what they don't do. They do not continue to pretend otherwise. They do not continue to pretend that the bank loaned them money. And the smart people get their payments back. As well you should. The bank acted as a money changer. They didn't loan you anything. Your promissory note funded the loan. Now, if you want to pay them, make payments to them anyway, because you think that's what you want to do, then that's fine. But then when they come to take the property as well, that's where people should really draw the line. Now, just remember, try to always be the plaintiff. And stay calm. Stay cool about it. It's not personal. It's just business. If anyone wants a phone consultation with me, the details are on the screen. And I love you guys all because you care about the truth. And you do care about what's right at the end of the day. Because right thinking and right strategies and right action will always lead to right results.